Welcome to the deep dive. Today we're doing something a little different. Instead of our usual review of articles, we're going deep, really deep, into a core topic in equity and trusts, breach of fiduciary duty.
Ah, yes. Crucial stuff.
Absolutely. Now, this deep dive is based on material the University of London has kindly made available to students. So just to be clear, this discussion is purely for educational purposes.
Exactly. We're aiming to help you understand these, let's be honest, pretty complex legal ideas. Make them stick.
Right. And hopefully help you get ready for exams by looking at key cases, concepts, facts,
Right.
really drilling down.
Okay, so fiduciary duty. Where do we start?
Mm.
At its heart, it's someone managing things, rights,
Yeah.
maybe activities for someone else.
Like a trustee.
The express trustee is the classic example, yeah. The paradigm, fiduciary, they often call it. Holding property purely for the beneficiaries.
But it's broader than just trustees.
Right.
Bro.
Yeah. Oh, much broader. Think about agents acting with their principals, business partners, company directors, loads of examples. The common thread is that discretion, that power they have to act on behalf of another. That's key.
Got it. So, for today, our mission is to unpack the main principles of breach of that duty using these Uni of London materials as our guide. We want to focus on how you should actually approach studying this.
Good plan. So we'll cover the big hitters.
Yeah. The no conflict rule, the no profit rule, self-dealing, fair dealing, equitable compensation, and those tricky trustee exemption clauses.
Okay. Sounds like a plan. Where first?
Well, first base has to be, what's the difference between a breach of fiduciary duty and just a straightforward breach of trust? They sound similar.
They do, and it can be confusing. Now, some argue every breach of trust is a breach of fiduciary duty. But the big case here, Bristol and West Building Society v. Matthew, drew a really important distinction.
Okay.
The court basically said, look, if a trustee just makes a mistake, acts carelessly, breaches their duty of care, that's not automatically a breach of fiduciary duty.
Right, so like making a bad investment choice.
Well, let's refine that. Imagine the trust deed bans investing in tech stocks. If the trustees do it anyway, that's a clear breach of trust.
Okay.
But it only becomes a breach of fiduciary duty if, say, the reason they bought those banned stocks was because they had some hidden agenda, a conflict of interest.
Ah, so it's the why behind the action, not just the action itself.
Exactly. Let's flip the example. Say the trust allows investments in shares. The trustees invest heavily in company X. That action seems fine, right?
On the face of it, yeah.
But what if one trustee's brother is the CEO of company X and the trustee got a secret payment for making the investment? Now, the action investing was allowed, but the reason, the conflict, the improper purpose, that's the breach of fiduciary duty.
Okay, that clicks. Doing something permitted, but for the wrong reasons because of the conflict. Unless, presumably, everyone knew and agreed.
Precisely. Fully informed consent changes things. But without that, the conflict taints the permitted action. That's a really vital distinction to grasp for your studies.
Definitely. So let's move on to one of those core rules you mentioned, the no conflict rule. Sounds fundamental.
It absolutely is. Bedrock principle. The law is incredibly strict about this. Simply put, fiduciaries must not put themselves in a position where their personal interests or duties they owe to someone else could clash with their duty to their principal.
Could clash, not even necessarily does clash.
That's the strictness. The potential for conflict is enough. They have to steer well clear of situations where their loyalty might be divided. And the case you absolutely have to know here is Boardman v. Phipps.
Boardman v. Phipps, right? Heard of it? Bit of a famous one. Remind us of the key facts.
Okay, so Boardman was the solicitor for a family trust. The trust held shares in a poorly performing company. Boardman and one beneficiary, Tom Phipps, thought they could turn the company around if they got a controlling stake.
Okay.
They suggested this to the trustees, but the trustees didn't want to or couldn't invest more trust money. So Boardman and Phipps used their own money and, importantly, information they'd gained while acting for the trust.
Ah, the information.
Exactly. They bought the shares themselves, took control, turned the company around, made a good profit for themselves, and interestingly, also increased the value of the shares the trust still held.
So wait, the trust actually benefited from what they did? That seems odd that it was a breach then.
That's the kicker, and why Boardman is so important. The House of Lords majority said even though the trust benefited, Boardman was in a fiduciary position, partly because of his role as solicitor, partly through his actions regarding the shares.
Right.
And because he used that position and the information gained from it to make a personal profit where there was a possibility of conflict, He had to account for that profit. They relied on a much older case, too, Keach v. Sanford.
Even though he acted honestly and helped the trust.
Well, honesty wasn't enough. Lords, Guest, and Hodson focused on the fiduciary position and the profit made. Lord Cohen had a slightly different take. He focused more on the conflict itself. Once Boardman decided he wanted the shares himself, how could he give impartial advice to the trustees about whether they should buy? His personal interest created a conflict.
Makes sense. Was it unanimous?
No. Lord Upjohn dissented quite strongly. He felt the majority was being far too rigid. He argued the possibility of conflict here was really remote, almost fanciful, he said, and the rule needed a dose of realism.
But the majority view won out, and it's known for being strict.
Incredibly strict. And that strictness has been recently confirmed. Look at Recovery Partners GP Ltd v. Rokazi from just 2023. The Court of Appeal explicitly followed Boardman.
So it's still good law.
Very much so. Recovery Partners reiterated, if there's a conflict on a profit, you account for it. Doesn't matter if you were honest or had good intentions. Fault or culpability isn't the point. It's the position of conflict.
That's a massive takeaway for studying this. The position, not the intention. And this isn't just trustees, you said.
Not at all. Boardman was a trust case, but the no conflict principle applies right across the board. Company directors think Regal Hastings, Ltd v. Gulliver. Agents look at industrial development consultants, Ltd v. Cooley.
Right, Regal Hastings, IDC v. Cooley. Cases to remember.
Definitely. And applying it in business context raises questions. Should it be quite so strict when commercial realities often involve potential conflicts, maybe dealt with in contracts?
Like a director sitting on multiple boards.
Exactly. Contracts might permit that. There's also the issue of fiduciaries setting up competing businesses. Generally, you can't, not without consent. Reed Thompson is a case on that.
Reed Thompson, okay.
But again, some argue that applying this too harshly, especially regarding business opportunities, could be economically inefficient. There are Canadian cases like Peso Silver Mines and Canadian Aero Services that wrestle with this corporate opportunity doctrine.
So a bit of a tension there between the strict legal rule and commercial practice.
There often is. Which leads to another point from Boardman and Recovery Partners, the idea of an allowance.
An allowance, even though there was a breach?
Yes. Even if the fiduciary has to give up the profit because of the conflict, the court might allow them to keep some of it to reflect their skill, effort, and risk in generating that profit. Like in Boardman, they acknowledged his work turned the company around.
So it's not automatic punishment?
Not always.
Ugh.
The court considers if it would be unfair, inequitable, is the term for the principle, to just take all the profit without recognizing the fiduciary's input. But, and Recovery Partners stress this, it's not a right. It depends on the facts. The worse the fiduciary's conduct, the less likely they are to get an allowance. And Recovery Partners is actually going to the Supreme Court, so this area might develop further.
Okay, that's a really interesting nuance, the possibility of an allowance. Now, the no profit rule, how does that fit in? Is it separate from no conflict?
It's very closely related. You could almost see it as a specific type of conflict situation. The no profit rule says fiduciaries can't make unauthorized or sort of secret profits just because of their position. Bray v. Ford is the classic case stating this.
Unless they're allowed to, obviously. Like
Yeah.
a salary or agreed commission.
Exactly. Authorized remuneration is fine. Directors get fees, agents get commissions, trustees can charge it that the trust deed allows. See Duke of Norfolk settlement trusts. The rule targets unauthorized benefits. Why? Because the lure of personal gain could easily conflict with their duty to act only in the principal's best interests.
Right. Stops their judgment being swayed by personal gain. And if they do make a secret profit...
They have to give it up. They must account for it to the principal. This used to be just a personal liability. They owed the money back.
Used to be.
Yes, because the big development came with FHR European Ventures, LLP v. Cedar Capital Partners, LLC in the Supreme Court.
FHR European Ventures. Okay, what did that change?
It established that such unauthorized profits are held by the fiduciary on constructive trust for the principal.
Constructive trust. Why is that significant?
It gives the principal much stronger rights. They get priority if the fiduciary goes bankrupt, and crucially, they can potentially trace that profit if the fiduciary has used it to buy other assets. It's a much more powerful remedy.
Wow, okay. That's a huge point from FHR. Can you give some examples of this no-profit rule in action?
Sure. Take trustees who use their trust's shareholding to appoint themselves directors of the company.
Yeah.
Any director's fees they get usually belong to the trust, not them personally. That was Ree McAdam.
Unless the trust doc says otherwise.
Precisely. Or William Z. Barton. The trustee worked for a stockbroker, got commission for bringing in the trust's business. He had to hand that commission over to the trust.
Makes sense.
Taking over a lease the trust was interested in for personal gain? Nope. That's Reed Thompson's settlement, different Thompson case.
Yeah.
The clearest example, bribes.
Bribes must be caught.
Absolutely. If a fiduciary takes a bribe, AG for Hong Kong v. Reed established that the bribe money and anything bought with it is held on constructive trust for the principal. Again, powerful tracing rights follow.
Okay, those examples really help illustrate the no-profit rule and the impact of that FHR decision. Let's shift gears slightly. Fiduciary dealing directly with the principal. You mentioned self-dealing and fair dealing. What's the difference?
Okay, key distinction here hinges on who is on each side of the transaction. Self-dealing is where the fiduciary is effectively on both sides.
Both sides. How does that work?
Think of a trustee trying to buy trust property. Legally, the trustee already holds the legal title, so it's more like the trustee deciding to transfer the beneficial interest from the trust to themselves and paying the trust fund. The conflict is blatant. Their duty is to get the best price for the trust, but their interest is to pay the lowest price.
Right, an inherent conflict.
Exactly. Because it's so inherent, the rule is super strict. The transaction can be undone, rescinded by the beneficiaries purely because it happened. Doesn't matter if the price paid was fair or not.
Wow, just the fact it happened is enough.
Pretty much, unless the beneficiaries gave their fully informed consent beforehand. And this applies even if the fiduciary does it indirectly, like through a company they control or a nominee.
Okay, so self-dealing, automatic voidability, unless consent. What are the remedies then?
If it hasn't happened yet, the court stops it. If it has happened, and the fiduciary still have the property, or it's with someone who knew about the breach, it gets reversed. Property goes back, money goes back.
And if they've sold it on to an innocent buyer?
Then reversal is impossible against the innocent buyer, but the fiduciary still has to account for any profit they made on the sale. Or if they sold it too cheaply in the first place, they have to make up the difference to the trust, ensuring the trust gets the full market value.
Very strict. Now, I remember reading about Holder v. Holder. Is that an exception?
Yes. Holder v. Holder is often cited, but you need to be careful. It's generally seen as an exception based on very, very specific facts. The self-dealing rule itself is incredibly stringent. Reed Thompson's settlement confirms that.
So what was special about Holder?
Well, the person involved had been named an executor, but had tried to renounce the role and effectively took no part in managing the estate or deciding to sell the farm in question. He later bought the farm at a public auction.
Okay.
The court decided not to apply the self-dealing rule because he wasn't really acting in the sale process. The judges felt the whole point of the rule, preventing someone from being both seller and buyer with inside knowledge, didn't really apply on those facts. The mischief, the rule targets, wasn't there.
So a rare case where the rationale didn't fit.
Exactly. Treat Holder as an outlier, not something that significantly weakens the general strictness of the self-dealing rule. It's the exception that proves the rule, almost.
Got it. Self-dealing, fiduciary on both sides, very strict. What about fair dealing then?
Fair dealing is different. This is where the fiduciary buys property from the principal, who is a distinct legal person. So, a trustee buying a beneficiary's beneficial interest under the trust, or maybe a company director buying shares directly from a shareholder.
So there are two clear parties this time.
Yes, which makes the conflict less inherent than in self-dealing. But there's still a risk, right? The fiduciary, because of their position, often knows more than the principal or has influence over them. There's an information asymmetry.
Still a potential for advantage taking.
Precisely. So the law doesn't automatically void the transaction, like with self-dealing. Instead, the burden of proof shifts heavily onto the fiduciary. This was confirmed in Reed Thompson's settlement. Again, different context, same case name pops up.
Okay, burden on the fiduciary to prove what?
They have to prove several things. That they took no advantage of their position, that they disclosed all relevant facts to the principal, that the principal had independent advice or at least didn't rely solely on the fiduciary, and crucially, that the price paid was fair, representing the full market value.
That sounds like a tough hurdle to clear.
It is. If the fiduciary can't prove all that, the principal can have the transaction set aside if possible.
And if it's not possible, like the property's been sold on?
Then, similar to self-dealing, the fiduciary has to make up the difference, ensuring the principal ends up with the full value they should have received.
Okay, let me see if I've got this straight for studying. Self-dealing. Fiduciary both sides. Voidable regardless of fairness, unless consent. Fair dealing. Fiduciary buys from principal, Transaction stands only if fiduciary proves absolute fairness and full disclosure.
That's an excellent summary. Captures the core distinction perfectly. Now, sometimes neither setting aside the transaction nor accounting for profit really fits the situation. That brings us to equitable compensation.
Right, like that solicitor example we had earlier, giving bad advice because of a conflict leading to a loss, but the solicitor wasn't actually part of the losing transaction itself.
Exactly that scenario. Rescission isn't possible against the solicitor. Account of profits doesn't fit if they didn't personally profit. So the client's remedy is equitable compensation money to make good the loss caused by the breach of fiduciary duty. The landmark case is Nocton v. Ashburton.
Nocton v. Ashburton, what happened there?
A solicitor advised his client, Lord Ashburton, to release a mortgage security. Bad advice, because releasing it actually benefited the solicitor's own financial interests in a related property deal. The client lost money when the primary borrower defaulted.
And the solicitor had to pay.
Yes. The House of Lords said the solicitor breached his fiduciary duty of loyalty due to the conflict and had to compensate the client for the loss flowing from that breach.
Okay. And how does causation work here? Is it just, but for the breach, the loss wouldn't have happened, like in negligence?
It seems to be a bit different, maybe more flexible than the common law, but for test. Lord Brand Wilkinson in Target Holdings Ltd v. Redferns talked about making good a loss that, with hindsight and common sense, can be seen to have been caused by the breach.
Hindsight and common sense. Interesting.
But it's not unlimited. There are important cases showing its boundaries, like Canson Enterprises, Ltd v. Bought & Co. from Canada, and an English case, Swindle v. Harrison.
Canson and Swindle, what did they show?
In Canson, a solicitor breached his duty by not disclosing a secret profit the sellers were making. The client bought the land anyway, then lost money later due to negligent engineers they hired for construction. They tried to claim all losses from the solicitor, arguing, but for the breach, they wouldn't have bought the land at all.
But the court said no.
Right. The Supreme Court of Canada said the solicitor's breach caused the loss related to the purchase price difference, maybe, but not the later losses caused by the engineer's negligence. That chain of causation was broken.
Okay, the subsequent negligence was a new cause. What about swindle?
Similar idea. Solicitor failed to disclose a personal commission when arranging finance for a client to buy a hotel. The client got the finance, bought the hotel, but the business failed due to her own poor management. She argued, but for the solicitor's breach, enabling the finance, she wouldn't have suffered the loss.
And again, the court disagreed.
Yes, the Court of Appeal said the solicitor's breach might have been a but-for cause of her entering the transaction, but it wasn't the cause of the business failure. That was down to her. So these cases show that even with equity's potentially broader view on causation, there still needs to be a common-sense link between the breach and the specific loss being claimed. It's not enough that the breach just created the opportunity for some loss to occur later through unrelated events.
That's a really critical point for analysis. The link between breach and loss needs to be substantial.
Yeah.
Okay, final main topic. Trustee exemption clauses. Can trustees just write clauses in the trust deed saying, I'm not liable even if I breach my fiduciary duty?
The million-dollar question. Well, maybe not quite a million, but it's complex and not fully settled. The starting point is Armitage v. Nurse.
Armitage v. Nurse. What did that establish?
It's the leading case on exemption clauses. It basically decided that trustees cannot exclude liability for their own actual fraud or dishonesty, or for acting recklessly, meaning not caring whether their actions harm the trust or not. That's seen as the irreducible core of trusteeship that can't be excluded.
Okay, so fraud and recklessness are out. What about other breaches of fiduciary duty, like an honest breach of the no-conflict rule a la Boardman?
That's where the uncertainty lies. Millett L.J. in Armitage suggested that the core duties might also include a fundamental duty of loyalty, which arguably encompasses the main fiduciary obligations like no conflict and no profit. If so, you couldn't exclude liability for breaching those either. But he didn't definitively decide that.
So it was hinted at but not decided.
Exactly. And the issue came up again more recently in Barnsley v. Noble.
Barnsley v. Noble. Did that clarify things?
Not entirely. It involved trustees accused of self-dealing who tried to rely on an exemption clause. The Court of Appeal actually allowed them to rely on the clause in that case. However,
there's always a however in law, it seems.
Isn't there just? The crucial point is that the argument that the duty not to self-deal is a core, non-excludable fiduciary duty apparently wasn't properly argued before the court in Barnsley. So while the case allowed reliance on the clause on its facts, it didn't settle the fundamental question of whether core fiduciary duties can be excluded if they don't involve fraud or recklessness.
So for exam purposes, no Armitage excludes fraud recklessness, but be aware it's still uncertain if other core fiduciary duties like loyalty, no conflict, no profit can be validly excluded.
That's precisely the state of play. Note the uncertainty, mentioned Barnsley, but also its limitations. It's an area ripe for future clarification.
Okay, brilliant. We've covered a lot of ground. Thinking about students preparing for exams based on the Uni of London materials and those sample questions, what are the absolute key takeaways they should focus on?
Right. Those sample questions are helpful. Question 1. The pub scenario with Richard and Paul is classic problem question territory. You need to spot the different breaches, conflict with the brother, secret profit from the signing bonus, maybe fair dealing issues with buying the pub itself.
And then apply the remedies.
Exactly. Compensation for loss, tracing the bonus, assessing market value for the pub purchase, maybe even think about if the brother could be liable as a third party. It tests identification and remedies.
Question 2 was more essay-like, defining breach through cases.
Yes, that demands understanding the rules. No conflict, no profit, self-dealing, fair dealing, but critically, how cases like Boardman, Regal Hastings, Bravey Ford, Holder, Thompson Settlement actually shape and define those rules. A top answer would try to connect them, maybe suggest an overarching principle.
And question 3, the music scout, Fred.
That's all about the no-conflict rule applied to business or corporate opportunities. It brings in Keach v. Sanford, IDC v. Cooley principles, the absolute necessity of informed consent before taking an opportunity yourself. And again, liability for profits or losses.
So if you were giving final advice for studying this topic.
Okay, number 1, know the core rules, inside out, no conflict Boardman, no profit FHR constructive trust, self-dealing strict, Holder exception, fair dealing, burden of proof.
Rules in key cases.
Absolutely. Understand the why behind the rules. Number 2, remedies. Know which remedy fits which breach rescission, account of profits, constructive trust, equitable compensation, knocked-in, target, Canson, swindle, causation issues.
Match the remedy to the breach.
Crucial. Number 3, exemption clauses. Understand Armitage v. Nurse on fraud recklessness, but flag the uncertainty about other core fiduciary duties and Barnsley v. Noble's limited scope. Pay attention to the nuances and differences between the breaches. Get those distinctions clear.
Focus on rules, rationale, key cases, remedies, and the specific nuances.
If you do that, drawing on the kind of detail in the university's materials, you'll be well prepared.
Fantastic. That's incredibly helpful. So just to quickly recap our deep dive today, we looked at fiduciary relationships, the absolute core rules, no conflict, no profit, self-dealing, fair dealing, the remedy of equitable compensation, and the complexities around exemption clauses, all based on the University of London's materials shared for educational purposes. Remember, understanding the cases and principles is key. For exams, distinguish the breaches, know the remedies.
Definitely. And maybe one final thought to leave you with as you study. Think about the purpose of these really strict duties. Is it just about stopping people losing money? Or is there something bigger at play? About upholding trust, ensuring loyalty, managing power imbalances in these important relationships?
Good question.
This whole framework, built up through cases like the ones we've talked about, shapes how we think about accountability, not just in trusts, but in so many areas of life and business. It's fundamental stuff. Thank you for joining us for this deep dive using the University of London's educational materials.